everyone. Thank you, Leah.
How's it, Andy? Good morning.
How are you, Zach?
Okay.
Good.
Technically, I'm on holiday. But it's awful good. All good.
Right on, Zach. I know.
Good.
Thank you.
Can't hear. I can't hear anything. I can't hear.
William, you guys are muted.
Why do you think that the bipartisan commission on presidential debates, which includes Republican members,
I can't hear.
The Hawaiian Homes Commission is being called to order. The meeting is being held via teleconference, moderated by me, William Isla Jr., from the DHHL office at Halepono'i 915420 Kapolei Parkway, Kapolei, Oahu, Hawaii. And today's date is Wednesday, September the 30th, 2020. The time is now 10:07 a.m. Pursuant to the Governor's August 20th, 2020 Supplemental Emergency Proclamation, COVID-19, Hawaii Revised Statutes, Chapter 92, regarding public agency meetings and records, is currently suspended through September 30th, 2020, to the extent necessary to enable boards to conduct business without holding meetings open to the public and to allow state agencies the ability to effectively and efficiently provide emergency relief and engage in emergency management functions. At this time, we are able to live stream this meeting via the DHHL website. Leah, would you please call the roll?
Commissioner Wall. Okay, Commissioner Helm,
Here.
Commissioner Kapu,
Aye.
Commissioner Kalekini,
Aye.
Commissioner Kaupu will be joining us shortly. Commissioner Namu'o,
Here.
Commissioner Nevis is excused, Commissioner Toria is excused, Commissioner Wall. He will be joining us shortly. Chair Isla.
Yes, I'm here.
5 members present, we have a quorum.
Okay, thank you. May I have a motion to approve the agenda?
So move.
Second.
Adam? Okay. Okay, anyone opposed? No, seeing none, the motion carries. No public testimony was received for this meeting on time, so we'll introduce Stanton Inamoto from the Department of Interior, and Stanton will introduce his staff and then talk about how to proceed. Commissioners, I would ask if you wouldn't mind holding your questions to after Stanton does the presentation. That would help us get through the presentation as quickly as possible, leaving additional time for questions. So, Stanton, good morning.
Good morning. Aloha, Commissioners. Aloha, Chair. Aloha, mai kako to those that are tuning in. On behalf of the Department of Interior's Office of Native Hawaiian Relations, it's an honor and pleasure to be here and talk story with you folks a little bit about our Homestead and Beneficiary Associations list. I thought that before we move into our presentation, given that there's some new commissioners on, and by the way, congratulations on all of your folks' confirmations over the past 9 months, I guess, or so. It's been crazy dealing with the legislature through COVID, but in any case, welcome. Glad to have you folks on board. I thought it'd be good to introduce some of the staff from our office. We have a very small staff. In addition to myself, I'm the Senior Program Director for DOI's Office of Native Hawaiian Relations. Joining us today, we have Kimo Kaloi, who's our director in Washington, D.C., and Lisa Oshiro Suganuma, who works with me here in Honolulu at the federal office building. Again, for some of the new commissioners, maybe just a quick overview of our office. We can certainly talk story with you folks more about it, but the authority for our office, for the Department of the Interior's Office of, well, Assistant Secretary of Policy Management and Budget, really came through in 1995 through the Hawaiian Homelands Recovery Act. Section 206 of that act lays out the responsibilities of the Assistant Secretary, especially with regard to land transfers and approval of amendments to the act. So that, as well as lands coming into the trust through that act. Our office, the Office of Native Hawaiian Relations, was officially kind of created in 2004 through an appropriations bill. And it lays out that we're kind of the entry point into the Department of Interior's roles and responsibilities with respect to the Hawaiian Homes Commission Act. But our enabling legislation actually goes beyond that to say that we have responsibilities for the broader Native Hawaiian community to ensure that consultation between federal agencies and the Native Hawaiian community can be facilitated. So we're sort of an intermediary or a liaison, if you will. Another role for our office that was mentioned in the 2004 legislation was that we were there as a technical assistance resource for various federal agencies in communicating with the Native Hawaiian community. So again, it's kind of this reciprocal or liaison role that we have. So today, we really wanted to talk more about a specific provision of our responsibilities, and that's touched on in the Hawaiian Homelands Recovery Act. And from that, we went ahead and developed specific federal regulations around for land transfers and for amendments to the act. And within that, we created a definition for homestead associations and beneficiary associations. So, and we devised a list by which we would keep track of those that register with our office. So we're focusing on that today. We're kind of going to go through a little bit of a tag team presentation. So I'm going to turn it over to Lisa Oshiro Suganuma, who will start us off, and then yeah, we'll go from there. So with that, yeah, maybe we can transfer it over to Lisa.
Hey, mahalo, Stanton. Aloha, commissioners.
Hi.
So we were asked to brief you on the Department of the Interior's definition of homestead association, which is found in our rule at 43 CFR, that's Code of Federal Regulations, Part 47 and 48, covering land exchange procedures and amendments to the Hawaiian Homes Commission Act. So we're providing a presentation on our Homestead and Beneficiary Associations list because we believe it will provide context as well as a better understanding of our definition of homestead association. So as Stanton mentioned, our presentation is divided into 3 parts. I will be covering the background and development. Kimo will present the definitions, purpose, and potential benefits of the Homestead and Beneficiary Associations list. And Stanton will discuss the management of the list. Finally, all 3 of us will be available to answer questions. So before jumping into the background and development of our list, we thought it would be helpful to provide you with the context of our rulemaking that resulted in our rules at 43 CFR Part 47 and 48. So as stated in the preamble to that rulemaking, the purpose of our rulemaking was to provide clarity in how the Department of the Interior administers the federal laws governing the Hawaiian Homelands Trust and the Hawaiian Homelands Trust funds, collectively the trust. Prior to the rulemaking, there were some misunderstandings and some disagreements over process, information, responsibilities, and authorities. So the rulemaking sought to clarify those. The rulemaking also reaffirmed the federal status and constitutionality of the Hawaiian Homes Commission Act and related federal laws governing the trust, all enacted by Congress pursuant to its plenary authority over Indian affairs. So the preamble to the rule clearly states and repeats in response to two comments that, quote, the HHCA is a cooperative federalism statute, a compound of interdependent federal and state law that establishes a federal law framework, but also provides for implementation through state law, end quote. So with that background and context, let's turn to the background and development of our list. So what was the impetus for the list? DOI is required to communicate and work with beneficiaries. Here, a section from the Hawaiian Homelands Recovery Act, Section 206, directs the Secretary to advance the interests of the beneficiaries and assist beneficiaries and DHHL. And I wanted to point out that beneficiaries is defined in the Hawaiian Homelands Recovery Act in Section 202, and it's defined as having the same meaning as the term Native Hawaiian as defined in Section 201 of the Hawaiian Homes Commission Act. So another reason for the list is we needed to overcome logistical challenges. In order to reach beneficiaries, there were no existing associations that encompass all homestead lessee and applicant beneficiary organizations. And we do find that it is more efficient to work through beneficiary organizations rather than trying to reach out to many more individuals. And then also one of our challenges was that DHHL's own contact list is not public. There was also a concern, since we have had our Native Hawaiian organization notification list at DOI since 2006, and we're using that for consultations. There are concerns that the distinct voice of beneficiaries needed to be heard. And in our rulemaking, our proposed rules sought testimony and correspondence from homestead associations, as well as sought summaries of outreach and consultation with beneficiaries. So one comment to the proposed rulemaking was, should the rule provide a definition of a homestead association? And the department agreed that the rule should provide a definition, and you will see listed in here, the Secretary added a definition based on the language provided in sections 204A2, 213, and 214A of the Hawaiian Homes Commission Act. So essentially, our Homestead Association definition is an amalgamation of this language. Also, you'll see that the definition kind of parallels the definition of Native Hawaiian organizations that are defined both in the National Historic Preservation Act and the Native American Graves Protection and Repatriation Act. So the rule provides the Secretary will maintain the list of the homestead associations as well as the HHCA Beneficiary Associations. So these are the references mentioned in response to that comment. The references found throughout different provisions of the Hawaiian Homes Commission Act. So you'll note the language controlled by Native Hawaiians, homestead communities, cooperative associations, as well as there are other provisions also referring again to cooperative associations, and then also 207C1B referenced in 214A, referring to the organizations formed and controlled by Native Hawaiians. So we note that cooperative association appears in the HHCA, but homestead association, that specific term, does not. So here's the Native Hawaiian organization definition, which you'll see in our definitions for both the Homestead Association and the HHCA Beneficiary Association, has some parallels in its structure and requirements. So in the final rule, we introduced two definitions, the HHCA Beneficiary Association and the Homestead Association. Together, we refer to them as the Homestead and Beneficiary Associations, or as an abbreviation, HBA. So I'll turn it over to Kimo.
Mahalo, Lisa. So technology is always fun when we're trying to switch between folks. But so what I'm going to cover is the definitions, purposes, and potential benefits section. Let's see if this will let me move it. There we go. So what is an HHCA Beneficiary Association? We have the definition pulled up for here for you guys to review. It's an organization controlled by beneficiaries who submitted applications to DHHL for homesteads and are waiting the assignment of a homestead. So one of the questions we're most often asked about HBAs is, what does the phrase controlled by beneficiaries mean? So for our purposes, we rely on each individual HBA to define the term control for themselves and view this as an endeavor to exercise self-governance and self-determination. The HHCA Beneficiary Association also represents and serves the interests of those beneficiaries, has a stated primary purpose, the representation of and provision of services to those beneficiaries, and they file the statement signed by their governing body of governing procedures and a description of the beneficiaries it represents. As you'll notice, the definition is really closely related to what a homestead association is under the regs. The main difference is that a homestead association is tied to a specific geographic area. The beneficiary association is composed of those waiting for an assignment. What's the purpose of the HBA list? Well, it's right at top. The purpose of the HBA list is to assist the Department of the Interior to communicate and work with HBAs in its efforts to administer the federal laws governing the Hawaiian Homelands Trust and the Hawaiian Lands Trust funds. What are the potential benefits of the list? Well, we see it as to help the community organize, define the geographic areas, and define the types of services they're going to provide. I think one of the great things about the list as well is that it allows the HBAs greater visibility with the federal government and allows them to more effectively communicate with the feds. The other question that we often get asked in regards to the HBA list is, does it qualify that HBA for a formal government-to-government relationship with the United States? And the simple answer is no. When requested to provide this briefing, again, this was one of the main questions. For our purposes here, I think it'll be clear if I answer that question by saying assisting HBAs with self-governance and self-determination does not mean that the HBA will establish a government-to-government relationship with the United States as a separate tribe under Part 50. While the HBA could conceivably apply under Part 50 for a government-to-government relationship, that individual HBA would have a real hard time meeting the standards because they need at least 9,000 Hawaiian Homes Commission Act beneficiaries and an additional 21,000 Native Hawaiians on their roll. We do use the term self-determination and self-governance in the way you might expect. Self-determination means that the HBA or NHO determines for themselves their actions, except where such actions are prohibited by law. This allows us to look to ourselves to determine our future and the prosperity of our people. Congress does require the federal agencies to work with NHOs and, for that matter, HBAs, who are considered the informal representatives of the Native Hawaiian community. This requirement to work with NHOs is necessary and based upon the fact that the Native Hawaiian community lacks a unified formal government. It's also respectful of the Native Hawaiian community's traditional means by which it governed itself beginning around the 1840s when the United States and other Western powers started to infiltrate the Kingdom of Hawaii's central government. And here we have the other question. Must all homestead associations participate on the HBA list? Again, this goes back to self-determination and self-governance. They don't. This is a voluntary list. If they want to engage in a relationship with the United States, this is about the best way to do it. I'm sorry, I'm having a little bit hard time with this manipulating my computer. Can multiple HBAs serve the same geographic area? Yes. There's no limit. We view it as the more people attempting to serve a particular geographic area, the better. And that brings us to Section 3, Management of the HBA List. Stanton? Oh, Stanton, you're on mute.
Thank you. Okay, here we go. So I know we covered a lot of background on the origins and the meaning of the list. I'll just summarize because I believe you commissioners have received the PDF of this. So I'll kind of walk through this a little bit quickly. How do homestead associations and beneficiary associations go through? Oh, let me try this again. I call my for some reason it's not moving through. I don't know. Well, in short, you know, whether a homestead association or a beneficiary association needs to or desires to register with our office, they need to submit the documentation that meets the definition. So what I wanted to cover here briefly is what is that documentation that they need to submit. Since I'm not sure if I have maybe I do have control. Let me go back to the previous slide, if that works. Any case, they need to submit and sign and certify a document and submit to the Department of the Interior what their homestead association is, who they are, and it has to be authorized by their governing board. And it's in the preceding slide, and I apologize that I can't get to that now. But in addition to that information, they also need to certify to us, their general contact information, mailing address, email, etc., a copy of their governing documents, as well as a summary of the kinds of services that they provide to their particular homestead community and the area that they represent. Because this is a submittal to our office, it's our intent to make that information publicly available. So there also needs to be a consent that they agree to have that information public. Try to go to the next slide. Okay, so once they're on our list, or once they rather submit their information to us, we'll take a look at it, make sure everything's complete. We do note in both our website as well as the information or sample template form for these homestead associations that submitting fraudulent or false material is a violation of federal law. And then, they can submit their information either to DOI's office in Washington, D.C. to Kimo, or they can submit it to our office in Honolulu. We get it either way. So the process for beneficiary associations is essentially the same. Again, I apologize, I'm not able to advance these slides. Okay, I think Lisa's got it. Okay. If somebody else has it. Next slide. Okay, thank you. So the process for a beneficiary association, again, the distinctions and definitions, a homestead association obviously implies a homestead. So there is an association created around a particular geographic area. The distinction between a beneficiary association is that it is for those that have submitted an application and are awaiting their assignment of a homestead. So yeah, separate potential association. The process is basically identical. Let's see, next slide. So they would prepare a package of all of their organizing documents, their contact information, a summary of the services that they provide to their beneficiaries or the membership of their association, as well as a description of those beneficiaries. And again, they would need to agree or consent to having their information made public. And again, similarly, once we receive that information, we will review it and with the standard conditions. And that, again, that information can be submitted either to Washington, D.C. or to our office in Honolulu. It can also be transmitted electronically, I should note, and we'll get it either way. So how long does association's member or placement on that list last? We have a condition for 5 years. It automatically expires at the end of that 5 years, and that we will notify those members or those associations on our list of the need to renew their registration. But generally, it's incumbent on that association to recognize that they filed with us and to renew or update their information as they go forward. So how do we maintain that information? We have a data file that we keep, as well as we post that data file onto our website. and that's probably its primary purpose. It serves to notify others who's on our list. Okay. So how do other federal agencies may utilize it? It's very similar to our Native Hawaiian organization notification list. If, for example, a federal agency is doing work that affects a particular homestead or Hawaiian homelands in general, they could reach out to the associations that are listed on our HBA list. Go to our website, pull it down, get the contact information, and then send out a notification to the addresses that are listed there, as well as a description of what it is the action is they're proposing, and provide contact information on how that particular association can reach back to that federal agency. Going forward, as I touched on earlier, there is a 5-year kind of time limit or lifespan for an association to remain on the list. So what do they need to do to continue to be on the list? Again, it's the responsibility of that association to notify us to say, hey, we still want to be on the list. Here's our updated information. Here's our request to still be on the list. And we ask for that to be sent usually within 30 days before that expiration, comes to pass. Standard information, all the information that was on their original documents, any updated contact information, as well as an affirmative statement by that association that, yes, we want to still remain on DOI's HBA list. Okay. Once we get that, we'll review it again for completeness. We don't do detailed verification or fact checking. We take the information as it's received. Again, we presume everything is accurate. And yeah, we just do a general review for completeness. Again, if it's not complete and they miss the deadline, their placement on the list will expire. So is it possible for an association, for whatever reasons, to want to be removed from the list? Yes, of course. They would need to send us a letter requesting that they be removed. Once we receive that, we'll remove them from the list. So we covered, again, a lot of ground. I'm sure you folks have questions. I just want to make note of our website where you can go to for additional information about the list. Currently, we have 2 Homestead and Beneficiary Associations on our list. That's the Sovereign Council of Hawaiian Homestead Associations and Waimea Nui. So if you go to our website, you'll see their information there. We received applications or registration information from 3 others. We're currently in the process of reviewing that. Once we get through that, we'll post them up on our website as well. Also on our website, I just want to make note, especially for the new commissioners, if you do go to dhhl.gov Hawaiian, you'll get to our main menu, and within that there's lots of information. I especially want to call your attention to our Hawaiian Homes Commission Act reference guide. It looks like something like this, if you're able. Oh, my camera can't focus. Anyway, it's a reference guide. We do have a few hard copies left and we can get them to you. But it does walk through the Hawaiian Homes Commission Act, as the history of amendments to the Act. It also includes the Hawaiian Homelands Recovery Act, the Admissions Act, as well as the regulations 43 CFR Part 47 and 48. So it's a good reference document to go back to should you folks have any questions. But in the meantime, you have us live here, so we're happy at this point, I think, to turn it back to the chair. Mahalo nui for your attention, and happy to answer any questions.
Mahalo, Stanton, Lisa, and Kimo. Commissioners, do you have questions? Do I see any hands up? Go ahead, Zachary.
Thank you, Chair. Aloha, Stanton. How are you?
Good.
Good. Yeah, I just have a question on the HBA. Is there any benefits for the association to be on the HBA list? What kinds of benefits does the association would be able to apply for or request for?
I'll take that one. The main benefit really is getting access to federal agencies, or federal agencies getting access to you. They know who to consult with if there's a federal action. But that is the main benefit in regards to federal agencies. And there's no real excuse for them to say, well, we didn't know we needed to consult with you if there was something going on. It's also a place to go through and be able to point and say, look, we are listed. If you're going to go work with, say, HUD on something, or if you're going to be working with, I would say, Department of Justice on one of their weed and seed programs, you can say, we've listed ourselves with the Department of the Interior.
Okay.
But there's no money attached. If you're asking if there's any money attached,
yeah, that's what I was.
No money attached.
Grants. Thank you.
Okay, thank you, Zach. Other commissioners? Oh, go ahead, Pauline.
Good morning, everyone. I'm not sure who's going to answer this question, but the list itself, when did you actually start this list with the federal government? I'm new, so I'm not sure.
So our rulemaking occurred in 2015 to 2016. So when the rule became final in 2016, we had that authority to create the list. And I believe we launched it at the 2018 DHHL Puvalu on Maui at August 2018.
Okay, my other question is this purely informational for the association? Is the Department of the Interior has this list for the associations and it's purely informational? The Department of the Interior does not do any monitoring of any kind of the association?
Do you want to answer that, Stanton?
Can you answer that, Mr. Kabua?
Yeah, no, I'm happy to. So again, we do use it for communications. We look, other federal agencies, we expect them to utilize that list when they're engaging in a federal action, but it's also meant for these HBAs to engage in self-governance and self-determination. It's really for them to make of it what they want. So it is somewhat open-ended in that respect. It's an opportunity for them.
Okay. I guess because I thought that you were trying to get some assistance in working with our association, and so I had all these more management questions, consequences and requirements. So there aren't any really requirements that you're asking of these beneficiary associations. You're just getting their information and putting them on this list. And in a way, I think that's good because the beneficiary associations are then now able to expose themselves to a lot of opportunities once they get themselves on the list. And I understand now why the list is so short from Hawaii, because it's new. It's relatively a new endeavor. So now I understand why there's only two. I think that also they probably need to get used to the fact that this can be a potential good thing for them. So, okay. So the 5-year registration, what is the purpose of the 5-year registration?
Yeah, I can answer that. It's generally just a way to make sure that these homestead associations or beneficiary associations, couple of things. One, keep their information current. Some of them are, you know, they have board of director meetings, they have elections, etc. So we just wanted to provide a period of space in which their information is current. Secondly, if, for example, an association goes through a process of amending its bylaws or what have you, again, it keeps the information current. We at DOI don't, you know, we're not going to be holding them accountable to, you know, you need to update your information with us. It really is the responsibility of the association to say, hey, we went through an election 2 years ago or a year ago, and we want to update you with our new board of directors. Again, the intent of the list, as Kimo mentioned, is about communication. So if members of a board depart and new members are in, we want to make sure that we have that information and can make it available not only to ourselves, but to other federal agencies.
Okay, thank you very much. This is
No problem.
very enlightening. Thank you.
Mm-hmm.
Okay.
I'm
Mike,
done.
I see you.
Thank you.
Thank you, Pauline. Mike, I see your hand up.
Thank you, Chair. Yes, thanks. Thanks for the presentation, Stanton and your team. I wanted to start off, so just for my clarification, the beneficiary associations are waitlisters. Is that correct?
Yes.
And the homestead associations is specific to an area. And
Yes.
then I guess for our purposes, there's numerous associations in the state on the different islands, etc. And so you're saying that there's only 2 of these associations that are registered with DOI?
Yes. At the
And it's
moment,
not,
yes.
and it's not a requirement that every association, I remember that, it's not a requirement that you have to register on the list.
Correct.
And I heard what Zach was saying, the benefits is getting federal support if you're on the list. So at the website, doi.gov, is that the location where associations can go to and register?
Yes, they can download the sample template. They have all of the list of information they need to submit, and yeah, file at their choice.
Okay, great. Okay, and before I get into another question along this line, I wanted to just request the reference guide. Is that accessible online, or if not, could I request a hard copy, please?
You're both correct. You can download the whole PDF from our website or specific sections of the reference guide, or if you actually, you know, want to have something you can hold in your hand, we're happy to mail you a copy as well.
Okay, thank you. No, I'll download it. Thank you for sharing that it's online. Okay, so I want to share something that's actually occurring in East Hawaii in one of our associations. We do have, I would say it's a dispute because there are more than one entity claiming to be the leaders of the association. Can this process, and maybe, Chair, maybe you can interject on this too, can this process of signing up to be on the list with DOI kind of, I guess, confirm which folks are the leaders of the association?
Again, I think it kind of, from our side, it would go back to how we use the list. And again, we primarily use it for communication and consultation purposes. When an association files with our office, we look at it, and if it's complete, we put them on the list. If not, we go back to them or whatever, talk story. To kind of the issue that you're getting at as far as resolving potential disputes between associations, that's really not the intent of our list. It really is, yeah, just for communication purposes.
Okay, no, I understand. I just needed to ask, and I appreciate that.
Sure, sure.
There is a lot of information, by the way, so if I'm sure there will probably be questions in the future. I mean, is it the best route to just go to the website, or what's your advice on following
Yeah,
up?
I would suggest if you have questions or, just want to seek information, go to the website.
Okay.
You can pull down a lot of stuff, but if there's specific things, Lisa, myself, or Kimo, we're all available to assist you. I believe the chair or Leah has all of our contact information. So again, feel free to reach out. I know it's a little bit crazy in these pandemic times. I would suggest maybe contacting us by email might be easier than just calling us by phone. So,
okay,
yeah.
That sounds great. Thank you. Thank you, Chair.
Thank you, Mike. Commissioner, any other commissioners? Questions? Randy?
Yes, so thank you for doing this presentation. It's really an important presentation because we deal with associations often, and as Mike points out, sometimes we are on the receiving end of disagreement and dispute. So some of the questions that have already been asked were some things that I was going to ask you as well, but this is a lot of information and I'm still formulating questions. So I know I will have questions later. And to Mike's question, we can reach you by email or through the chair's office, and I fully expect that will be occurring. One of the questions I do have is, would an association that's being formed to act as an interim association for development that has not yet occurred, but they have formed as an interim association and have taken certain positions, for example, naming the project, doing site visits, etc. If an organization applied for recognition through your process, given those set of circumstances, would they qualify?
Yeah, I guess a couple of things. I would be, because that term recognition can be loaded and mean a lot of things to different people, I'm a little bit cautious to use that term. But if an association were to form of beneficiaries who meet that definition around a particular project, associate themselves, develop all the documents, and file with us, I think we would receive that, and we would probably, because the project is not out of the ground yet, or leases have not been actually awarded, we would look at them more as a beneficiary association than a homestead association. And perhaps when the development were to come out of the ground, leases are awarded, people are moving in, they can, at least for our purposes, be transfer from a beneficiary association into a homestead association. That said, there is a level of semantics around that, Commissioner, in that regardless of whether they're a beneficiary association or they're a homestead association, they're on our list. and again, for communication and consultation purposes, we would reach out to them equivalently, however they chose to define themselves. So again, it's as Kimo touched on earlier, one of the benefits of registering with our office is to make themselves known. It's for a group of beneficiaries or homesteaders within a particular community to say to the federal government, here we are, we exist, this is us, and if there's any federal action that may affect us, you need to consult with us. So it's a way of making themselves known.
Okay, so I think that's great. And my hope then is that all beneficiaries, associations, and people who want to form an association begin to understand that you are here for them, and that they begin to plug into that's being made available to them. So that's my hope, is that the word gets out and everybody has an awareness that they can plug in to this venue the federal government is offering. So thank you for answering the question.
Thank you, Randy. And as you commissioners try to formulate or think about new questions, I'm going to go to Tyler. Tyler has a question.
Well, Kimo, Stanton, Lisa, mahalo nui for doing this. I just wanted to ask some clarifying questions I think that might help the commissioners on certain issues, and it might be really good for the beneficiaries. So some of these I think we've already discussed, but I think it would be really helpful to get answers to them out there. So Kimo, with the slide that you mentioned where you said that inclusion under 43 CFR parts 47 and 48, and by inclusion I mean being defined, does not create or recognize any government-to-government relationship. That's important because the way we define a federally recognized Indian tribe is the act of the United States federal government recognizing a formal government-to-government relationship. So to put it more simply, since that's really all legal terms of art high up in the air, does the definition of an HBA federally recognize them?
It's an apologize. I apologize. Kalamai for it dropped off. I don't know what was going on with this computer, but like Stanton said earlier, the term recognition is really loaded. It has a lot of meaning in regards to the constitutional relationship between indigenous communities and the United States government. Like I said, the simple answer is no. There's no formal government-to-government relationship that's established between that HBA and the United States.
Right. No, I understand that, but
that would have to happen through the Part 50 process.
Right. So they're not federally recognized.
They're not federally recognized.
Okay. Does defining them under 43 CFR parts 47 and 48 give HBAs any legal standing?
Does it give them any legal standing? I think the standing would have to, they'd have to make that claim on their own, and it would depend on the case.
Sure.
But for purposes of federal recognition, it does not. I mean, there is, and what Congress has decided to do is basically they've said there is one Native Hawaiian community. We are recognizing one indigenous community. Congress has not said that we're going to recognize multiple organizations or multiple governments. There is a history of the United States, and there are requirements within U.S. statutes that federal agencies work with NHOs, and for that matter, HBAs, as the informal representatives of the Native Hawaiian community. But they have said, Congress has said that they're only recognizing one.
Okay. No, that's super helpful. I think people have been looking for answers to these questions. My last one is, does defining HBAs under 43 CFR parts 47 and 48, does it do anything to shift the administrative responsibilities and the duties and the authority delegated to the department under the Hawaiian Homes Commission Act, does it shift any of those things to HBAs or give HBAs any increased role, rights, and responsibilities as to what has previously been delegated to the department?
Well, you know, you still have a job. The part of where this also comes from, part of the purpose is that over the last 100 years that the United States has been working with the state of Hawaii on oversight of the trust, the communications have been sort of just between the state and the feds. And that has been an issue for properly obtaining good information about how to best serve the Native Hawaiian community. And the HBA list helps us to fix that issue. I mean, when we, I'll give you an example. So we go through, we have a federal action going on Hawaiian homelands, or there's a NAGPRA issue. You find a grave. It's really easy for us to consult with DHHL. I pick up the phone, I call you up and say, hey, they're out in Waianae, there's this grave site. And all of a sudden we're communicating. We don't have that same, or we haven't had that same ability to pick up the phone or email the beneficiaries in Waianae or anywhere and say, hey, there's an issue with this grave site. What should we be doing? Who should we be talking to? It doesn't allow opportunities for beneficiaries to go out and, for that matter, seek funding to do programs for, I don't know, loan assistance, for community development, all sorts of other things. The communication has only been with DHHL. You guys still have so much work to do there, and this doesn't shift that responsibility, but it hopefully will help allow more hands to help our people on the lands to get the services they need.
Yeah, thank you, Kimo. I think it's really helpful. I think seeing how this is a very functional tool as a communications list or a contact list or a phone tree is very clarifying. Thank you.
And I do want to say this isn't just a phone tree. We are going through and we're showing what people are doing, what their kuleana is. This provides an opportunity for HBAs and for our people to help themselves and to really, engage and work with the federal government. So,
may I also add to that response?
Sure. Go ahead, Lisa.
As I mentioned, we've had our DOI Native Hawaiian Organization notification list since 2006. And I want to mention that we have about a dozen homestead associations on that list. I guess I wanted to share that there isn't this vast vacuum of communication. We have been communicating with and in touch with various homestead associations. And through our NHL list, we also have been distributing notices about grant opportunities, other federal register notices about different rulemaking affecting our communities, our lands, our resources, as well as job opportunities that are available here in Hawaii, as well as elsewhere that may be of interest to our community. So we hope to see more register on the HBA list, but we also do continue to receive registrations for our NHL list from homestead associations.
Thank you, Lisa. I see Mike's hand up first, and then I saw you waving Randy. So Mike first, and then Randy, and then back to Commissioner Helm.
Okay, thank you, Chair. Yeah, just it's a quick question. I wanted to ask. With regards to the Beneficiary Association and the Homestead Association, do both associations are they in do they have the same rights and privileges with regards to being on this list, and is there any difference or differentiation that DOI sees?
No. Registration is on our list or filing with the department, as Kimo mentioned earlier, is voluntary. So that in and of itself does not create any difference between those that have elected to register with our office and those that have elected not to. So yeah, there is no difference.
Okay, and then would it be correct to state that there's no difference between the associations that are made up of the waitlisters and the association that are made up of folks that are on the land?
That's
The
correct.
homestead associations.
Yeah, the difference between the two classes of HBAs, there's no real difference in how they're treated.
Okay.
I think the one thing that you will see with the homestead associations, though, is that they're tied to a geographic area. And generally what you'll see happen is that a federal agency will, when they're considering input that they receive on a federal action, if it's happening within that geographic area where those folks are living or they have a high interest, they're likely to go through and weigh that input a lot more heavily.
Okay. Appreciate it. Thank you.
Okay, thank you, Mike. Randy, and then Zach.
Lisa, did you want to go through and add to what I said?
Sorry, yes, if I could just add, if you also look at our rulemaking, I think specifically in part 48 with respect to amendments to the Hawaiian Homes Commission Act, we do have in the Secretary's determination of whether or not a proposed amendment to the Hawaiian Homes Commission Act advances the interest of beneficiaries. There are specific questions that ask about the interests of those who are applicants on the waiting list. So that is one of the reasons we do differentiate them, so that we can reach out and make sure that we're hearing from applicants as well as from lessees.
Thank you, Lisa. Randy?
Yes, so Lisa, actually, the question I'm going to ask, Lisa helped to answer parts of it. And my question is, recognizing that this is a really valuable and important process for our beneficiaries to participate in. My question is, given the level of outreach that's currently underway with the DOI and the manner in which our beneficiaries have responded, would you consider your current outreach successful, at least successful, or in need of improvement?
I couldn't hear.
Randy, could you repeat the question, please?
Well, I think our outreach, sorry, there's some other interference noise, but I think our level of outreach can always be improved because there are still communities and organizations that we meet who aren't even aware of our NHO list, as well as our HBA list. We continue to, I guess, hear from more as some of our notices to either the NHO list or to the HBA list often do get forwarded on to other entities. And when they find out about the list, then they're often coming to us to register. But yeah, we appreciate people making reference to our lists and encouraging people to register with us. But we're also open to your suggestions on how we can reach out to your communities.
Okay, thank you for that. I think what I will probably do at our next Mokopuni Council meeting here in Maui, I will pose those questions to the beneficiaries in attendance and see what kind of feedback I might get or we might get, and then bring that back to all of you. But thank you for that.
Yeah.
Okay, thank you, Randy. Zachary, I know I have acknowledged you, but David had his hand up
Go ahead,
for
David.
a little while. Would you mind?
Yeah, that's fine.
Yielding to David. David?
Yeah, sorry. So I had a couple of questions, but thank you for putting on the presentation. Do we have any beneficiary organizations that are actually registered at this point?
Yes, we have two that are on our list and also posted on our website. One is the Sovereign Councils of Hawaiian Homestead Associations, and the second is Waimea Nui.
Right, but those would be Homestead Association, right, as opposed to beneficiary organizations.
It's both.
They're both.
Yes.
Oh,
Well, actually, I think Shaw is both. Waimea Nui is a homestead association. And
Okay.
then we have the other three that are still pending. And I believe one of them is a beneficiary association.
okay. Thank you. And then my other question is, when you folks first were going through the definitions of the beneficiary associations and native homestead organizations, it says it has to be controlled by beneficiaries. And then, so I'm wondering if that is more form over substance, because then you said you folks don't check on it. So one of my concerns is if you had one beneficiary and 30, not even Hawaiians that were supporting them, they could then say they were a native beneficiary organization or a homestead organization that could then register with the federal government. I'm just wondering why there's a little bit of due diligence on the organizations that submit their names to be sure that they are controlled by beneficiaries as opposed to non-beneficiaries.
I think part of what it comes down to is just statute. We don't have any statute that would go through and allow us to police that, whether somebody's lying or not. There are statutes, however, of making false statements to the federal government that come with jail time, but that's not something that Department of the Interior oversees. So
right. So yeah. So I'm just wondering how if you had that situation that really isn't assisting beneficiaries in their self-determination, in their self-governance, right? Because I thought that the idea was for beneficiaries to be involved in self-governance, beneficiaries to be involved in, being successful and improving their lives. So I just have a little bit of concern about that because it seems like because you're not checking, it's really not a false statement, right? If I have one beneficiary and 30 people from Peru that are then supporting that person, at least under your definition, that would qualify as a native beneficiary organization.
Well, the only thing I can really say is it hasn't been an issue as of yet. And if we have to go through and find some ways to deal with situations along those lines, then we'll look to deal with it. But at this point, it hasn't been an issue as of yet.
Right.
But
well, on a realistic level, I know that there are homestead associations that are not necessarily controlled by beneficiaries. Right, they are controlled by perhaps successors. Or potential successors. They are controlled by spouses of beneficiaries, but they're not necessarily beneficiaries. So but it doesn't seem like the federal government is delineating between the terminology that you use, which is controlled by beneficiaries. So if that is just form over substance, then maybe it doesn't matter. But I'm thinking that if the government is offering grants to beneficiaries, that the government would want to make sure that they are in fact benefiting beneficiaries and not just big N native Hawaiians if it is intended for Hawaiian homes beneficiaries. So, and in communicating with these organizations or making yourself known, I'm assuming that one of the reasons you make yourself known is so that at some point you can benefit from any potential grants that may be out there. Thank you.
Sure.
Thank you.
Okay, thank you, David. We'll go back to Zach.
Yeah, thank you, Chair. Yeah, my question is similar to what David just had mentioned. As one of your criterias as far as the HBA requirements, you must be on the waiting list. Is that correct?
For a beneficiary association, that they've submitted an application and they're awaiting a lease.
Okay, so what if they're not, but they meet the blood quantum? But they must be on that list.
Yes, they have to be awaiting an assignment, and that was in part a decision by our solicitor's office to go through and say there had to be a connection to the land in order for the organization to be defined in 43 CFR Part 4748.
So are you? Do you folks do investigate if those members are from the list of waiting list?
No, we rely on their statement, on a signed statement from them. And again, it is against federal law to go through and make a false statement. So we can't make people be honest on these things. But I think as you go through, if they end up going through a grants process, and that's not what this is, but if they go through a grants process, I mean, my hopes is that there would be a bit more vetting of that organization. And
yeah, because
generally
sometimes
those grants are associated with serving that a specific underserved community. So you have that protection in there as well. But I understand your concern. You make a very good point.
Yeah, because one of the ways of being eligible for grants and assistance is to build up your membership. The bigger your membership, probably the better chances of you getting qualified for more opportunities for grants. And sometimes they bring in their spouses, they bring in their kids, and they're just add up to the membership, but they're really not on the list. You know what I'm saying? So, but they just want to build up the membership to make it look. So that's my question. Thank you.
It's a great question.
Okay, other commissioners? Has this discussion stimulated questions? Further questions? If not, I will ask two questions. Kimo, with regards to the desire to engage in more self-determination, the key phrase that you had earlier on the screen was pursuant to existing law. And I would like you to expand upon that, because sometimes, the department is faced with beneficiary organizations or homestead associations that here you say something like it's to engage in self-determination, and they go out and they do things prior to checking with the department, and it's not pursuant to current law. And then the department looks like the bad guy because it has to go in and request that the action that they took come back into compliance. So I just want to make sure if you can repeat that so that the commissioners clearly understand that it's aspirational. The goal to self-determination is aspirational, and it doesn't, these rules do not grant authority, do not grant the ability for homesteaders to do anything outside of the current law, especially the Hawaiian Home Commission Act, and any rules that we have. So I asked that question on behalf of the commissioners so that they have a clear understanding.
Okay. Yes, you're correct, Chair. This does not authorize any new rights or privileges or for HBAs to go through and violate state law.
Okay, then my question is a real life situation, and it's very similar. Do the rules require any state agencies or private entities to negotiate directly with these homestead associations or beneficiary organizations, things like community benefits? Because I have had to engage with private entities who have been told that, and it puts the department in a very awkward situation in having to be the bad guy with these associations and beneficiary associations and homestead associations after they think they've negotiated something.
You know, we generally make a habit of not answering questions that are posed as hypotheticals because
well, this was a real case. I mean, there are several real cases that
and we also don't have all the information in front of us. I will say though that this doesn't create any additional rights or privileges. I have a hard time seeing where all of a sudden an HBA would be able to negotiate some type of benefits package just based upon their placement on the HBA list. That's not something that I've seen as being in 43 CFR parts 47 and 48, and there's nothing in our documentation that would suggest that. But to be definitive, I'd have to actually see the specifics of the case. And
okay,
so,
no, I appreciate that.
Is my answer sufficient?
It is,
Yes.
and in this particular case, I see some commissioners smiling, so it's sufficient at this point. I think in the future it may require additional information. So those are the questions that I have. Commissioners, I'll come back to you because this meeting was really to get you informed about 43 CFR parts 47 and 48, so that when you're involved with beneficiary associations or Hawaiian homestead associations, you know exactly, you've had it from the horse's mouth, what it means and what it doesn't mean.
I appreciate that you called us the horse's mouth.
Yeah, my grandmother used to call me the other end.
Oh.
And I deserved it. So looking back, I was. Commissioners, any additional questions? Okay, seeing none and seeing no
I
hands.
do.
Commissioner Helm.
Oh,
Yeah,
great, sorry.
yes, thank you, Chair. This is not related to your presentation. By the way, the presentation was excellent. But, you know, I just need to know what the DOI would suggest or tell me. This is kind of like related to a legislative action, legislative presentation we had in the last meeting. Regarding to medical cannabis on Hawaiian homelands for cannabis dispensary. What is the Department of Interior's, I just wanted to know, what do you guys think of this?
I don't know what the United States position is on this, or what the U.S. Attorney's Office has taken regarding the growing of cannabis. I just don't know. And I would be remiss if I made any sort of comment, unless Lisa or Stanton, do you know the position?
No, I don't. And I was just going to echo your comment, Kimo. At this point, we just don't know, so we really can't comment.
Okay, thank you.
And I would punt it to Jason, your AGs.
Thank you.
Thanks, Lisa.
Just trying to share the love, Jason.
Okay, thank you. So first Pauline and then Randy.
William, I just want to say, this is my first encounter with Mr. Kaloy. I know Stanton, and we've had Lisa before, but Mr. Kaloy, I want to thank you very much for this presentation. It's been very informative, and we hope to work very positively with you and your staff. And this is very enlightening. And William, thank you so much for having us get all this information.
Thank you.
Mahalo.
Mahalo, Pauline.
Mahalo.
You know, I wore the tie for you guys just so I didn't want anybody thinking that I was like pretending I was in Hawaii. So just had to do the DC thing. So.
Okay, Randy.
Okay, so going back to the question about where the federal government stands on cannabis, the answer I'm hearing is that no one knows. But I think about the medical marijuana facilities currently operating in Hawaii, and as a result of their understanding on the position of the federal government, they have to do everything in cash transactions. My understanding is banks won't accept the money. So that's my question. Not knowing versus the reality on the ground for medical marijuana facilities here in Hawaii, responding to their understanding that the federal government does not currently recognize cannabis as a legal substance. My question goes back to all of you. How is it you don't know what their position is?
So I'll step in and run a little interference here. The question unfortunately falls outside of the ambit of the agendized item. I would just recommend that we would hold those questions and we could put it on another agenda maybe if we want to have another public discussion about it, or if it's something that we need to talk about in executive session from a legal perspective. That's probably the more appropriate place. I just don't want to put our DOI folks in an uncomfortable position.
Okay, well, thank you, Jason. I appreciate that. I have a question that I will bring up later at the proper time. And I asked the question because we do have beneficiaries that would like the department to support legislation that will allow them to grow cannabis on their land as a business opportunity. And so that's why I'm asking the question. But Kalamai, I didn't mean to put you on the spot, but I still have that question.
So
okay, thank you.
Let me answer the question in regards to an amendment to the Hawaiian Homes Commission Act. And that's related to 47 and 48. We would review that. If the state proposes to amend the Hawaiian Homes Commission Act to allow for a specific activity, that's something we would review. And our review process is pretty thorough. So we would be able to get an answer back if in fact the state decides to go through and propose such an amendment to the Hawaiian Homes Commission Act.
Okay.
Okay, so sorry, Kimon, that would be the same for a state law being amended to allow for that activity on the Hawaiian homelands, right? Wouldn't it also be reviewed by DOI?
If
Yes.
there was an amendment to the Hawaiian Homes Commission Act or a state law that affects Hawaiian homelands, yes, we would have to review that before its application could be made to Hawaiian homelands. It's just like when there was a law that was passed allowing for extension of leases, and that extension couldn't generally be applied to Hawaiian Homelands leases without the Secretary's review and Congress's approval in the case that we recently reviewed.
Okay, thank you for that clarification, Kimo.
Sure.
Commissioners, any other questions that come to mind regarding 43 CFR 4748? The staff want to ask a question? I see some notes going back and forth, so. Well then, come on, no shy. Gigi, don't be shy. Come to the table, ask your question.
Commissioners.
Aye.
Gigi with the planning office. I guess for me at the staff level, you know, I guess I need some more context of why is the commission, what is the commission's interest in having a definition for a homestead association? You know, we've heard DOI's presentation. They have a definition, but it's, again, they've been very clear. Its purpose is as a contact list. So I think that's where I'm struggling at the staff level is what would our purpose, you know, for the commission and for the department, what would our purpose be for having a definition?
So I'll jump in.
Sorry, big picture question.
That's okay. No, I'll jump in. I mean, I think that basically would be for the same purpose, right? Because we have beneficiary consultation all the time in which we address groups of people who fall under the BA definition, as well as established homestead associations. As you can tell, I mean, we're not able to grant any one of these organizations any more legal standing than the federal rules allow for. So there has been questions from the commissioners in the past. What is a homestead organization? If the commission desires to have further community discussion on whether or not we should adopt our own definition or take a look at the DOI definition, that's something that it's not on the agenda, but we can certainly have discussions if there's desires.
Yeah, and also just food for thought, and I think DOI had mentioned this as well. Just keep in mind that, you know, if that is a concept to be entertained of a definition for an association, we also, you know, will need to look internally as a department for the support, you know, the due diligence that I think Kimo mentioned, you know, and monitoring, you know, of the associations to meet those definitions. You know, because it sounds like from the Department of Interior presentation, it's really a self-certification, you know, which we can look at as well. You know, but if we're going to go further in any kind of due diligence, you know, as Commissioner Kapu had mentioned, of checking the boards, that they are in fact waitlisters or lessees, checking the members of the association. You know, if we're going to kind of go into that level of checking, that's also a good thing to do, then we'll need to look at department resources to be able to do that. So that's my 2 cents.
Okay.
Thank you.
and Gigi's, you know, she brings up something that's important because she struggles without clear guidance in terms of the grant
Yes.
reviews, the grant compliance. So yeah, it's definitely something that, let us take a look at it at the staff level, and then we may have an agenda item for commissioners to discuss. Okay. Randy?
Yeah, to Gigi's point, why are the commissioners seeking more information on the definition? I think it just goes to us being part of a presentation that requires that we go through a process of asking questions and trying to seek clarity based on some of the issues that we deal with, recognizing that the department has issues that they must deal with as well. But this is just part of a process to ask questions, get clarity, and try to end up at a better place. So that's why the questions are being asked.
Thank you, Randy. Zachary and
Yeah, Chair. Yeah, that's why I asked for unrelated questions other than the presentation, because I really don't know when we're going to have this opportunity again. Because I would have golfed today if it wasn't for your presentation. I thought this was so vital for me and for the rest of the commissioners to listen to your presentation. But I have another question. The DOI, do they have any, let's see, lobbyists to, whether it's, if it's a possibility to request for funding for Hawaiian Homes land, for more monies for infrastructure for Hawaiian Homes? Is that restricted, or do you have a lobbyist or someone to, when it comes to the budget, do you folks request for funding for Hawaiian homelands or more funding?
Short answer. You want to answer, Kimo? That's fine. Go ahead.
Sure. Sorry. The short answer is the president is our lobbyist. So,
okay.
We go through every year and we make recommendations through the budgetary process, and based upon the budget that's put through by the Office of Management and Budget, they go through and provide a budget to Congress. What also happens is Congress will then look at that, and depending on the relationship between the president and Congress, the Hawaii delegation will go through and put forward their priorities for funding for Hawaiian homelands or what have you. So we don't have a lobbyist except for the president, really, and the Office of Management and Budget.
And I guess I would also add to Kimo's comments. I agree with what he said, but we as government employees are expressly prohibited from lobbying Congress. So there's a big firewall between the executive agencies and those in Congress. So, yeah.
Thank you.
all right. Any more questions from commissioners? Okay, seeing none, I definitely want to thank Stanton, Lisa, and Kimo for the enlightenment that Tyler asked for in his pule this morning. I think we all got enlightened, and we will continue to seek more enlightenment in the future. I know commissioners are planning to send questions in email to you folks. So mahalo for establishing this relationship and being willing to work with us, really on behalf of the trust that was heard loud and clear, and to serve beneficiaries. So thank you so much for your presentation. Commissioners, thank you for taking time out of your day. And staff members, thank you for taking time out of your day. Be safe, and we will see you the next time we get together.
Okay. Mahalo, Chair.
All right.
Mahalo, Commissioner.
Ahoy ho.
Ahoy ho.
Ahoy ho.